2027.
Yes.
The matter is then still postponed until 22 December. Regional Court 3 for the attorney, accused in custody, no bound, to be detained at the Secunda police cells.
You understand that? Bafana Mahungela. State recalls case number RC 772 of 23. State versus Bafana Mahungela. Appearances are as before. My learned colleague was still busy.
The applicant may be seated. Mr. Consultant.
Your Worship, I'm indebted. Worship, I have made so far legal propositions and without citing any authority to support what I'm saying. I now refer the Honourable Court to a book called A Guide to Bail Applications by M.T. Mokoena. It's a first edition, I guess so, and I refer this Honourable Court to page number 54, which I'll read into the record. May I proceed, Your Worship?
May proceed.
If it's a pity we do not have, I'm told there's no machine, there's no paper.
Yeah.
We would have prepared the relevant pages. Unfortunately, we'll read it into the record.
May proceed.
Thank you, Your Worship. Now, on page 54 of M.T. Mokoena, A Guide to Bail Application, the following is said by the author. And I read at a paragraph which is the paragraph up there. And reads as follows. In legal proceedings, whether civil or criminal, it is usually the party bearing the onus of proof who also carries the burden to lead evidence first. That's what we did. In the case of Schedule 5 and 6 offenses, the accused, who is also the applicant, bears the onus. The essence of Section 6011 in brackets A indicates that as far as the applicant who is affected by this provision is concerned, it is incumbent upon him or her to present his or her case first and for the prosecution to answer. And that is set in S versus Porthen and others 2004 in brackets 2 SACR 242 in Cape Town at 256. And proceeds to read, a bail application who is subject to Section 6011A provisions obtains a potential and unintended advantage if the inquiry is conducted in a manner which is at odds with the plain legislative intention. That is set in this and continues to read. Now he obtains a potential and unintended advantage if the inquiry is conducted in a manner which is at odds. And we submit that this inquiry fits this description on all fours. I proceed to read. The question of honors in Schedule 5 or 6 offenses is not universally applicable to all offenses. As a result, in cases falling under 1 or 7, for example, the honors lies with the prosecution, which must therefore start leading evidence, common cause. The determination of the charges which the prosecution is to pursue is therefore of crucial significance in the determination of the offense before the court. That's what the court held in S. v. Shabalala, 1998, Volume 2, SACR 259C, Cape Town. Such determination in the end determines who bears the honors and therefore who needs to start leading evidence. It is therefore imperative that sufficient facts should be placed before the court in order to establish whether, for example, Section 6040 finds application in a given case. That was said in S. v. Stenfeld. And then I continue to read, where the prosecution relies on the provisions of Section 66011 as the basis for its opposition to bail, it may be worthwhile to present a full charge sheet with all the particulars of the alleged offense clearly set out. That was said in S. v. Shares in 1996, 1 SACR 715 here in Transvaal at 718. And I continue to read. Besides establishing a level of certainty regarding the content of the charges, this prevents the prosecution from presenting vague, general, and often unsubstantiated allegations which serve only to exaggerate the charges which the prosecution could actually prove. In the same vein, one should not lose sight of the technical aspect of the provisions which classify offenses as Schedule 5 or 6 or otherwise. As if this authority has not said it, I now refer the Honorable Court to what is called the Bible of the bail charges. And it's called the Bail a Practitioner's Guide. It's the 3rd edition by Jon van der Berg. So I'm reading from Mokoena. I'm now referring to van der Berg. And in page 63, he echoes the same sentiments. And really, these are learned colleagues. They don't just come out and write books without even have conducted any research. These are reliable sources. And we cannot turn a blind eye to them and hope that things will be brushed aside. Now, on page exceptional circumstances, just one moment, Your Worship. I think I missed the page. Schedule 6 applications 15. Yes, on page 50, I beg your pardon, 76, it will come later on. At page 50 reads as follows, at 6.2.2 paragraph. In the previous, it says, let me see.
Page 56 or something.
I said what? 56. Just one moment. Yes. Just one moment. I think I missed the page, but I can inform this on record that the author emphasizes the point which is made by Mokoena. And if one reads the bail applications, one will realize that most of the authority relies on. Here we are. Yes. Now, let me come back to this point, just to check. Now, on page 63, of the same book, it said, exceptional circumstances do not require innocent persons to be punished purely on the basis that he or she allegedly committed a gruesome offense. And that is said in S versus C, 1998-2, SACR 721, and Cape Town at 726. Right, then let me pause at that and then deal now with my heads, which I have given. I haven't forgotten about Van der Berg. Heads of argument reads as follows. In the regional division of Gauteng North, head at Alexander Court, case RC 772/23, in the matter between Bafana Mahungela, the applicant, and the state. Heads of argument on behalf of the applicant. And I guess my learned colleague has been furnished with a copy and is reading with me. Can confirm that? Thank you. Paragraph 1. Your Worship will pardon me that I don't have a roadmap here because we didn't know what's coming. And I'm sorry, I'll just indicate when necessary. The Honourable Court, in ruling whether or not for the application for bail stood to be decided in terms of Section 6011 A or B of the Criminal Procedure Act, of Act 51 of 1977, in bracket CPA, found by virtue of a possible head trauma to the head, the applicant should proceed on the basis that the bail application was one envisaged in terms of Section 6011A. Paragraph 2. However, on the possible pre-planning, premeditated murder, the Honourable Court emphasized that its ruling did not imply that the applicability of Section 6011 could not be revisited should the evidential material to be adduced dictate or indicate otherwise. In other words, insofar as matter is concerned, the court never made a ruling. It said it wanted to listen to the evidence and will make that decision at a later stage. Paragraph 3. It is respectfully submitted that the evidence and or evidential material, in brackets hereinafter referred to as the evidence as a whole and in context, supports the applicant's contention that he did not commit a planned or premeditated murder, robbery with aggravating circumstances, and rape. As a result, the Honourable Court is respectfully requested to find that the present application does not fall within the ambit of Schedule 6 application as is envisaged in Section 6011A of the CPA. Paragraph 4. It is respectfully submitted that the evidence did not even show that the applicant committed any of the charges, and as such, the application for bail should be considered as an application not even falling within the ambit of Schedule 5 of the CPA. The evidence presented at least points to a charge of either theft and or defeating the ends of justice. Accordingly, the state bears the honors to show that the interest of justice demands the applicant's continued incarceration. 5. It is submitted that the inference is that the state embarked on a strategy to introduce the provisions of Section 6011A, notwithstanding insufficient facts, so as to expose the applicant to the harsh tenets of Section 6011A of the Criminal Procedure Act 51 of 1977, and hereafter I'll refer to it as the CPA. 6. In particular, the state had access to all the available evidence and at the very least should have known that the available evidence fell far short of establishing the existence of a planned or premeditated murder, robbery with aggravating circumstances, and rape. The state knew full well that the Schedule 6 bail application would subject the application to a burden which is very difficult to discharge. As post facto, the purported reliance on Schedule 6 has been exposed. The poor quality of the evidence of the state further expose an endeavor on the state to avoid disastrous shortcomings in the state case. To us, the defense, these are nothing but amounts to sensational claims or simply difficult to prove accusations. The state made a promise, and I alluded to this fact. The state made a promise to the court that its case stands on the video footage, but later took a U-turn. Paragraph 8. It is now very clear why the state could not rely on a certificate as envisaged in section 6011A in caps of the CPA. As if this was not enough, no provisional charge sheet was filled by the prosecution. 9. Notwithstanding the above submissions, the evidence will be meticulously analyzed with due regard to the provisions of both Schedule 5 and Schedule 6 and Schedule 5 of the CPA, because the court had made that ruling. And we now proceed to spell out what Section 6011A of Schedule 6 states. States as follows. Notwithstanding any provisions of this Act, when accused is charged with an offense referred to in Schedule A, in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist, which in this circumstance exist in the interest of justice, that the interest of justice permit his or her release. Paragraph 11. Schedule 6 in relation to murder, robbery, and rape provides that, and I quote from that provision. It can only be murder if it was planned or premeditated. We have made submissions on that. C part of it, and this is crucial. Rape or compelled, as contemplated in that schedule, what is contained is that the only rape which falls under this schedule should be rape or compelled rape as contemplated in Section 3 or 4 of the criminal law, meaning the law amendment, Sexual Offenses and Related Matters, Amendment Act 2007 respectively, or robbery with aggravating circumstances. Now, let me pause here to mention this omission which is committed by my learned colleague. My learned colleague referred to murder, and if one reads the schedule refers to Section 3 or 4 of the Criminal Law of Amendment Act of 2007. And if you don't spell out very clear about this act, then the rape can fall under Schedule 1 or any others. The same would apply with robbery, with aggravating circumstances. They are clearly governed by, if you want to classify them under Schedule 6, there are requirements as per the Act as to what has to be mentioned. My learned colleague, with the greatest respect, never referred to this Act. The SORMA Act, the CLA, Criminal Law of Amendment Act of 2007. I proceed to read paragraph 12. The South African jurisprudence on Section 11A, Schedule 6, made it clear that when an accused is charged with Schedule 6, bail should not be granted unless the existence of exceptional circumstances are established by the accused, which bail is discharged on a balance of probabilities, and we submit that we have satisfied the requirement. By giving this on record, viva voce evidence, they can come with 10 or 20 affidavits, they don't one match one single, consistent, reliable witness who testified. Paragraph 13. As such, the section supra imposes a formal onus on the accused to adduce evidence to satisfy the court that exceptional circumstances exist which in the interest of justice permit his or her release. I have mentioned authorities as follows: Bota and Anner, 2002 in brackets 1, SACR 222 SCA. S versus Felion, 2002 2, SACR 550 SCA. And these cases, I've mentioned them deliberately because they're binding to this court. They're higher courts, and whatever principle, and according to the stare decisis, the Honorable Court is bound by these authorities. Continue. S versus Mazibuko, 2010, Volume 1, SACR 433 KZP. It's a High Court matter which also binds the Honorable Court. Rudolph versus S, in brackets 2010, 2 all SA 178 SA. Your Worship will realize our authorities will rely either on constitutional court cases or SCA cases or higher court cases, which are binding to this Honorable Court. We are not thumb-sucking nor taken by feelings. We rely on the law, and the law is guided by the evidence tendered in court and the facts. I proceed to read paragraph 14. If an accused has established a prima facie case of the intended prosecution failing, there is a duty on the state to rebut his or her defense to that effect. Can it be said that the state, and this is said in S versus Matebula, I already cited it. Can it be said that the state rebutted the viva voce evidence of the applicant? With the greatest respect, we submit there's absolutely no rebuttal. And if there is any, because what we have, cross-examination, are just mere questions by my learned colleague. That is not evidence. The evidence is the affidavit. The affidavit cannot be matched with the viva voce evidence. The viva voce evidence carries more probative value compared to the affidavit. And later on I'll show that in Killian it was said that the applicant should have went for viva voce. And yeah. Now I proceed paragraph 15. As I promised, this is now a constitutional court case. In S versus Lamin, S versus Laza and others, S versus Jobert, S versus Kitekat, 1994, volume 4, SAs 623, Constitutional Court at paragraphs 76 and 77, the court found that exceptional circumstances are not circumstances beyond the circumstances beyond the circumstances enumerated in section 60 in brackets 4 to 9. I cite now what the court said and I say CS versus Lamin. At paragraph 76, the Constitutional Court, which is the apex court, says, likewise, I do not agree that because of the wide variety of ordinary circumstances, in inverted commas, enumerated in section 64 to 9, it is virtually impossible to imagine that what would constitute exceptional circumstances, and that the prospects of their existing are negligible. In requiring that the circumstance be proved to be exceptional, the subsection does not say there must be circumstances above and beyond and generically different from those enumerated. Ordinary, the essence of it or the crux of it is ordinary circumstances can also be seen to be exceptional circumstances, cumulatively or individually. Under the subsection, for instance, the accused charged with the Schedule 6 offense could establish the requirement by proving that there are exceptional circumstances relating to his or her emotional condition that render it in the interest of justice that release on bail be ordered, notwithstanding the gravity of the case. Other examples are readily to hand in the small body of the case law that has already been established in short period since the 1997 amendment came into operation on 1 August 1998. I now proceed to read what the court said in paragraph 77. In conclusion, therefore, I am of the view, and it was the decision was made by the Honorable Kirchler, who was then one of the highest justices and not an ordinary justice in the Constitutional Court, under the guide of the Honorable Chaskalson, Chief Justice. So this should not be taken very light, and I guess my learned colleague will come up with another Constitutional Court case which nullifies this one. In conclusion, therefore, I'm of the view that although the inclusion of the requirement of exceptional circumstances in Section 60A limits the right enshrined in 35(1)(f), it is a limitation which is reasonable and justifiable in terms of Section 36 of the Constitution in our current circumstances. 16. In R versus Letawana, 1997, Volume 11, BCLR 1581, Witwatersrand in Johannesburg, it is pointed out that in any further development of the principles of bail, every court is obliged to take full account of our Constitution in the light of the requirements of 39(2) of the Constitution, that a court must promote the spirit, purport, and object of the Constitution. I add, in addition to 39(2), I'll urge the Honorable Court to also look at the founding values. Freedom is one of the founding values stated in the Bill of Rights. It is also stated as a right in the Bill of Rights. Section 7 and 8, and if one read also Section 2, spells out what the court has to do. Must promote, protect, and ensure that these rights which are enshrined in the Constitution, guaranteed by the Constitution, have been taken care of. And here, right to dignity. I'm not concerned even much about freedom. My client said, once released on bail, I'll stay at my parents' place. I won't go to the malls. Why? Dignity is infringed. And black dignity and white dignity should be equal according to Section 9 of the Constitution. It has no color. The Constitution is deliberate. It doesn't speak of any color. It doesn't say purple, gray, black, white, or what. It says all. Everyone. Proceed to read paragraph 17. In S versus DV and others, 2012, paragraph 2, SACR 492, GNP, the court held at paragraph 7, and I quote, an applicant in a bail application is given a broad scope to establish the requisite circumstances, whether they relate to the nature of the crime, the personal circumstances of the applicant, which is the accused, or anything else that is particularly cogent. And then I have stated authorities as versus Lamine. Personal circumstances to an exceptional degree may lead to a finding that the release on bail is justified. And I will show from also Van der Berg, if you read what defines exceptional circumstances. Ordinary circumstances on page 99, it is stated in Van der Berg that ordinary circumstances can be exceptional circumstances. Likelihood of acquittal, as we have shown, so far, the state cannot say they've got a case of robbery, murder, and what, no. So much, and my learned colleague stated in his own words that the investigation is incomplete and is still pending. DNA, but even for rape, there's no need for them to look for the DNA. Because if it comes and it's positive, we are not worried. M1 and 2 solves the mystery for us. May I proceed? And I can also mention that in page 103 and 104, in page 101 and 103 of Van der Berg, they say the preparation of defense is also an exceptional circumstance. Some authorities even go further, that police should not effect an arrest, keep people in detention pending investigation. Because investigation can be done. You cannot get excited by T-shirts. I mean, that's for the media. They haven't studied law. But legal minds should know better. Here you're dealing with somebody who is mandated by Section 2053 of the Constitution. The police shall protect, promote, and ensure that we are safe. But here they are. With a T-shirt, we're going to lock you in, as if the T-shirt is $1 million asset. We are going to still keep you in detention. Now, the police are not mandated only by the Constitution, 2053, Section 2053. They are also mandated by Section 13 and 14 of the SAPS Act, 1995. And I do not hear anyone, the IO saying, I am working under the SAPS. I have been mandated according to the Constitution. In other words, if you don't mention it, then you don't know it. And that is shown by the police assaulting my client and even not reading any constitutional rights to him. And I never had the prosecution or the police regretting for this abuse. They even went to privacy. Open up your phone. Why? Because they realize they want to build a case with him. Why? They don't have a case at hand. And why don't they have a case at hand? They can't explain how the body landed at that George Lee Park. They can't explain why that body was covered by a rag. At what time did this body arrive? Why did they miss it? Why do they see it later on at 8:18 and not later, and not earlier? We are not losing sight of the fact that there are houses on the wall. If indeed a person is being killed by the accused person, they would have also checked for any markings on his body, because people don't easily die. They die fighting. Even a chicken, which some of us even eat in Christmas time, we slaughter. And the chicken, before it dies, it kicks. And it will leave some traces either on your clothes or any other thing. A question was raised that on your T-shirt, you are hiding your T-shirt because it had blood. In this statement, no one talks about it. As to where that a piece of evidence comes from, it baffles the mind. I proceed to read, and I wish to mention the following. There's a case called Nundalal. I can't remember the citation, but in this private prosecution of Mr. Zuma, they dealt with it. There is, if I can remember well, I think it's page 12. It refers to what is a prima facie case. It says a prima facie case is a case which at least has some real evidence, documentary evidence, and in addition, viva voce evidence to support allegations which are made. The standard is not high. It's not that of beyond the guilt of accused. Now, another fundamental mistake I shouldn't miss this one. Questions were asked to the accused. I put it to you that the version you are giving is not reasonably possibly true. No, that's a wrong standard. In a bail application, we are dealing with the merits to show that the state case is weak. But if one says the version which you are giving is not reasonably possibly true, that's for the trial court. Another issue which was raised was, are you normal? And the court assisted. What did the court say? Maybe you should say, deal with a reasonable man's issue, test. And the question was asked, are you do you think you are reasonable in the manner in which you behave? The reasonable test is only there to prove negligence. And the charges here is not culpable homicide. The element for murder is intention in its three forms: dolus directus, indirectus, dolus eventualis. It has no negligence. It's not like poker, section 6, which refers to ought to know, or knew, or ought to have known. So the issue about the reasonable man test is misplaced with the greatest respect. Such questions were not supposed to have been allowed by the prosecution. And it shows that once the prosecution raised such questions, it was nothing else, and I say it with respect, an act of desperation, and they were moving the bail application to the trial court. And that is not what the court has to determine. The true inquiry is as to whether the accused has proved exceptional circumstances, and it is in the interest of justice that he be released. I proceed to then read, is it paragraph 18? Then in S versus DV and others, paragraph 8, in the context of section 11A, the exceptionality of the circumstances might be such as to persuade a court that it would be in the interest of justice to order the release of the person of the accused. A certain measure of flexibility in the judicial approach to the question is required. Who says this? It's not me. S versus Mohammed, 1999-2, SACR 507, Cape Town, at 513-4 to 515, 513F to 515F, close bracket. Paragraph 9 thereof reads, it will be futile to attempt to provide a list of possibilities which will constitute such exceptional circumstance. To incarcerate an innocent person for an offense which he did not commit could also be viewed as exceptional. That's applicable to this case. It could not have been the intention of the legislature in section 64A of the Act to legitimize at random the incarceration of persons who are suspected of having committed Schedule 6 offenses, who, after all, must be regarded as innocent until proven guilty in a court of law. In other words, and it thus is in S versus Jonas, 1998-2 SACR, and then at 677 southern side of Eastern Cape. And I will show later on if there is a weak case which is suspect to serious doubt. That's also an exceptional circumstance, and it's applicable in this matter. Proceed to paragraph 19. The state, in its endeavor to advance the case of a planned or premeditated murder, robbery with aggravating circumstances, and robbery, sought to rely on allegations by the prosecutor. The learned colleague deemed it fit to address from the bar the heads of argument and the evidence of the investigation and the private are some of, here we are anticipating, and no heads are there. I think what I have to read is the evidence of the investigating officer and the private investigator are some of the affidavits to be relied upon. And I proceed to state as follows. The contentions by the state will be dealt with hereunder. 19.1. The facts as stated by the prosecutor are on record and I do not intend to repeat them. 20. If the state intended to allege that it was a planned premeditated robbery with aggravating circumstances and rape, it should have referred to these offences as falling under criminal law amendment. I've mentioned this point and I restated it was not mentioned. And if you look at the schedule 6, this Criminal Law Amendment Act 105/1977 is written in black and white, and that also is been dealt with in Lahore versus S in brackets 2002 GOL 10257 SCA. Says if you put them under 6, please mention Criminal Law Amendment Act. 21. As demonstrated above, every allegation by the prosecution was exposed as not supporting the state's contention of any of the crimes preferred. I will briefly deal with exhibits, but it will be a repetition. I'll deal with them at a later stage. Now, submission further by the defense, and paragraph 22. An accused is, in the absence of a conviction by a court of law, constitutionally presumed to be innocent. That is contained in section 35(3)(h) of the Constitution of the Republic of South Africa, 108 of 1996. 23. The grant or refusal of bail is a discretionary decision under judicial control, and judicial officers have the ultimate decision as to whether or not, in the circumstances of a particular case, that bail should be granted or not. And it's contained in S versus Lamine at paragraph H to I, 89E and 90B to D. I wish to add the following. This discretion should not be used in an arbitrary, irrational, unjustifiable, unreasonable manner. It should be applied judiciously. 24. Exceptional circumstances as a concept has not been defined thus far. The Constitutional Court declined to define it, but made it clear in paragraph 76, which I read into record, that even so-called ordinary circumstances, in inverted commas, may serve to establish exceptional circumstances. See also S versus Rudolph, 2010, 1 SACR 26 SCA at 266 H2I, and Moy versus S 162/12 SCA 79. There is no onus on the state to disprove exceptional circumstances. The accused must, on a balance of probabilities, prove that the state case was non-existent, weak, or subject to serious doubt. And this case, we respectfully submit, satisfies this requirement. It's not even non-existent, weak, it's a mirage. And we didn't satisfy a prima facie case. And to show that there's malice, I need to talk about that. To show that there's malice, we are not speculating to make a submission that is why the IO, who's sitting next to the prosecutor, and the prosecutor chose willy-nilly which documents to give and not to give. And we strongly suspect at some stage, if this matter were to proceed, there are some shocking revelations to be found in the docket. Proceed to read. 24. Exceptional circumstances. It's not been defined, I said, Rudolph and so on. 25. An accused claiming innocence and that he will ultimately be acquitted must prove his future acquittal on a balance of probabilities. Our client did that. And surely, no one can come and say, he said in his own words, if I may quote him, under examination in chief, under cross-examination, consistent in saying, I took the clothing. Sunglasses I never took. I don't know where this story comes from. They searched at my place, never found any sunglasses. I take blame for taking the clothing and hiding it in the drain. He takes responsibility. He's frank and honest. He takes this honorable court into his confidence. He says, but the t-shirt or the top, I took and threw it in a bin. And we asked him its price and so on and so forth. And we asked him as a follow-up, would you deny having committed a crime if state would prefer charges of theft or defeating the he said yes. Because what did I do? I interfered with the dead body when I didn't know that it's dead, panicked, took the clothing. Why? And this, for me, and I wish to mention this, the problem about reasonability is that it varies from one person to the other. Even today, I studied a long time ago. I'm told about the reasonable person. I haven't seen one. Because why? Reasonable man depends on the facts and circumstances and the context given. Not so. You can't have one reasonable man. What's the color of this reasonable man? We can ask ourselves. Well, how does he stand? How does he sleep? What is reasonable in the circumstances by the police, the prosecution, three heads in one, and the private security? What could have been reasonable is to sit down, put the puzzles together to say, besides this young man who is black and 21, can we scout for another option and open up our heads and investigate on other avenues? No, they chose not. We're not going. That to us is reasonability. If they failed, when they have state resources to can do it, my client doesn't have any state resources. He is a scared, frightened, shocked young man. He says, even when there are funerals in my family, I do not have the guts to view the dead. And then now, in court, he has to be changed into this person who has to be reasoning so hard and divorce the emotions which he was in, the state of shock, and to be quoted as, are you really normal? I find that, in fact, to be offensive to my client. It's an insult. Because my learned colleague is not a doctor. It's just maybe a specialist in law, in prosecution, and maybe one of the best. But no, I know Billy Down. Sorry to say that. Paragraph 25 then states authorities, as versus Matebula, Van der Berg, Bail, A Practitioner's Guide, 3rd edition, 232-4, at paragraph 716.5, regards this as this issue about as outrageous honors. When accused a person confronted with allegations that he has committed a Schedule 6 offense does not make a prima facie case of the prosecution failing. There is no duty on the prosecution to present evidence in rebuttal. And it's also said in Matebula. Now, it shows if my client got in the box and was grilled or shuttered by cross-examination, and out of fear, in a state of shock, couldn't answer some of the questions, the state, which had preferred a higher threshold, Schedule 6, wouldn't have had a duty to rebut. But they are rebutting because they see there's something heavy which they never anticipated. In other words, rebuttal means there is something. And it's not only one affidavit. That shows they're at least trying hard to equal the evidence which my client tendered in court, when they had no duty to rebut. If they didn't have a duty to rebut, they would have said, what you're saying is bizarre, nonsensical, you don't pass the test of Schedule 6, you don't even deserve to be answered. We leave you like that to dry in the box. But no, it bothered them. It really bothered them. And it even created some emotions sometimes. Paragraph 26, bail proceedings are not to be viewed as a full dress rehearsal for the criminal trial. And during the bail application, the duty of the court is merely to assess the prima facie strength of the state case against the applicant, as opposed to making provisional finding on the guilt or otherwise of the accused. The making of credibility, findings of the witness on the merits of the case against a bail applicant is left to the trial court, which will ultimately be better placed to assess the evidence in its totality. In other words, and this is said in S versus Van Wyk, 2005, Volume 1, SACR 41, SACA at paragraph 6. The court is not here to make any evaluation about the guilt and prophesy on the acquittal. It is not its duty. Bail is very clear. It has jurisdictional facts and circumstances to satisfy, excluding credibility findings and so on. Why? We don't have any full disclosure of the docket in accordance with S versus Shabalala. It's a constitutional court case. I must say, we had difficulties not only about disclosure of documents, but the difficulty of not knowing what's coming. We took a very high risk, and the court should take that, in fact, judicial notice to that fact. Your worship will remember that my learned colleague said the following when we were discussing the issue about Schedule 6. He said something to the effect, I am adding other charges. I'm not Mafiri. This is not the court for Mafiri. I have read the docket, and I know why I prefer this, knowing full well that there's exculpatory evidence which he concealed in the docket in the form of M1 and M2, assisted by his police on the left. So what we are saying here, and it's not a personal attack, please, I'm saying it with the greatest respect. But the truth, as painful and hurting as is, cannot be avoided. Paragraph. Now we come to this question. Was the applicant's evidence truthful, impressive, reliable, and probable? And did the state unleash solid evidence? I asked this question at the time when I asked myself this question last night. I didn't have the affidavits. I was also speculating and hoping I'll find my ground, but at least my guts, to some extent, were right. Paragraph 7. It has repeatedly been said that an accused who elects to go by way of an affidavit rather than presenting viva voce evidence in a bail application runs a distinct risk. Recently, in Killian versus S, in brackets 2021, in the Western Cape High Court, 24 May 2021, where the accused was charged with murder, which resulted under Schedule 6 of the CPA, the Honorable Beans Watt J. Judge observed, in my respectful view, correctly, that in choosing to attempt to discharge that honors on affidavit, an accused person runs the risk of not resolving disputed allegations which might arise in the process. Now, if I gave an affidavit, one could have happened. Because charges were added for the first time on the 13th, I didn't know about them. I was supposed to then postpone to then go and change my, what is that, affidavit. Or I would have then had no choice to take the accused and then put him in the box. So I had to choose between a rock and a hard place. Is that how the law operates? Fairness and justice does not do that to its human beings. And I'm saying we ran this risk with great success. And I'm very proud of the young man who is only 21 years of old at Varsity College. Although he didn't pass other courses, he's still young. To repeat a subject doesn't mean, to fail today doesn't mean you fail tomorrow. In fact, failure in life is a good instrument to teach you how to succeed in life. So some people realize failure it means you are a failure. No person can be. Because it is only God who can determine our destination, not us as advocates or prosecutors or police. Now, I deal with comparative cases because there was an issue about the public outcry, there was an issue about the TVs and what have you. And I start with this case. I want to remind the Honorable Court about the case, and it's on paragraph 28, Oscar Pistorius and the granting of bail. I can inform this Honorable Court that my colleague, Barry Rue, never ran the risk of taking Oscar into the box because he was not faced with this kind of situation. Him and Gerinel conducted themselves in a manner which befits honorable prosecutors and honorable advocates. They knew what was to be in dispute, and that is why their bail application didn't take ages. And I wish to also mention the following. It seems he was arrested somewhere in and appeared the following day. In other words, he didn't have to stay for so many days in custody, although there was direct evidence that he is the one who killed River and was ultimately found guilty. But bail was granted to him. And if I'm not mistaken, even bail pending appeal, when matter was taken to the SCA, he was granted bail. Despite the fact that there were women who were singing from the Women's League, the ANC, and so on, public outcry. The court applied its mind to the given facts. Now, when Oscar Pistorius didn't get into the box to be subjected to so much scrutiny in the form of cross-examination, was granted bail, it simply shows that the legislature never intended to deprive people bail because it's a horrendous crime, it's gruesome, it's ugly, and it's against a person. There's us versus Kamikel. I'll deal with all these cases. Now, let's, and I then gave it a thought. I checked, because I did my research. I checked an article, and it's dealt on page 28.1, an article by Anthony Bourdain, Constitutionally Speaking, and it was published on the 19th of February 2013. He succinctly states, and I quote him, "The circumstances under which a court may grant bail to an accused person charged with a heinous crime are widely misunderstood in South Africa. Although the rules around the granting of bails are relatively strict if compared to any other constitutional democracies, a court is not supposed to withhold bail merely in order to punish the accused or to demonstrate disapproval of the alleged crime committed by the bail applicant. To do so would amount to a form of detention without trial, which was widely used during the apartheid era against political opponents of the National Party regime. It's not me, it's him. I fear that many South Africans, considering the merits of granting bail to murder accused Pistorius, will lose sight of this important fact. And I guess this is what is happening in this case. And I agree fully with Anthony Bourdain. And he is correctly and precisely on point. He continues on paragraph 28.2 to mention that, and I quote him, as is often the case when decisions about bail are made, the public, and in bracket, it must be said, sometimes also the presiding officer, he says, conflate the abhorrence of the alleged criminal act or their suspicions about whether the accused might eventually be found guilty of the crime, on the other hand, with the question of whether exceptional circumstances exist to grant bail. On the exist to grant bail on the other hand, they then insist that bail should have been denied. This is often in conflict with the human rights-based interpretation of the relevant section of the Criminal Procedure Act that was provided by the Constitutional Court. Proceed to read. He says, I know this is not a popular point to make. I'm also aware that some people might wrongly believe that in pointing this out I'm demonstrating an insufficiently abhorrence of the crime that Pistorius is being charged with. But I would invoke the words of Justice Arthur Chaskelson in S versus Makwanyani, which is also a constitutional, to answer this conceptually muddled charge. He says, the very reason for establishing the new, Chaskelson said the following, the very reason for establishing the new legal order and for vesting the power of judicial review of all legislation in the court was to protect the rights of the minorities and others who cannot protect their rights adequately through the democratic process. Those who are entitled to claim this protection include the social outcasts and marginalized people of our society. It is only if there is a willingness to protect the worst and the weakest, which are women, right, amongst us, that all of us can be secure that our rights will be protected. The weakest are the women. And Pistorius had committed murder to River. In this case, there's no direct evidence. There's no direct evidence. No, we are not being told even about the video footage that we even have footage which shows the accused having this unknown instrument applying force to the accused. No one says absolute silence about that. And one wonders why. But the reason for that is nothing else but to show that there's, even now as we're speaking, there's no evidence to support that. We have had the affidavits, even the affidavits by both the investigating officer. They don't say X saw my and or say, if they don't want to mention the name, somebody saw him. Somebody saw him doing this thing. And I wish to mention that I will show the court most of the crimes of murder which are committed in the houses of the deceased, right? And I can state the case of Ruode versus S, the businessman in Cape Town. Murders his wife, and he said that the wife was suicidal, right? And then what happened? The Honorable Judge Sally Sope, then, I know she's remarried, and I'll show that what is she saying about this crime. He was granted bail, notwithstanding the fact that there was direct evidence pointing to him. He was granted bail pending appeal also. But what makes it so difficult with this poor little 21-year-old? When others can get it, is there any equal treatment from what we can see from the cases which we are dealing with? We submit with respect that really, if we can ponder deeply to these cases, there are good guidance that bail is not meant to punish. It's not anticipatory punishment. And as Mrs. Atchison says that, by whom? The Honorable Mohammed J. Then the DJ at the Supreme Court of Appeal, but he was in Namibia at the time. Proceed to read. As Mrs. Rode in the High Court of South Africa, case number CC 43 in Cape Town, at page 6, paragraph 13, the court held, and the judge said, the victim of these offenses was none other than your wife with whom you had been married for 22 years. The murder of your wife was callous, brutal, and shocking. Susan died a painful and gruesome death. She did not die instantly. It took her a while to die. She suffered in the last moments of her life, eventually succumbing to death. The degree of violence which you meted out at your wife was egregious, excessive, and exhibits horrifying aggression. You executed successive blows and fatal force in the taking of her life. Completely disregarded her bodily integrity. It is a significant feature of this crime that you did not hesitate in commission thereof, for you did not call for medical assistance. Instead, you left her to die and you waited for her to die. Despite all this, he was granted bail on affidavit and bail pending appeal. I've said that. Now, I wish to read what I found from a document by the Honorable Justice Meyer. There's a document here. Yeah, this one. In this document by the Honorable Meyer, who is now the head at the SCA, no? Sorry? Yes. She wrote an article. In the article, the head of the article is Judicial and Legal Responses to Gender-Based Violence and Femicide. I'm not going to read everything. But on page 2 and paragraph number 2, she refers to gruesome stories which reminds her of Karabo Mokoena from Johannesburg, whose charred remains were found in a shallow hole, buried like vermin. River Steenkamp, I've dealt with that. Former Banyana footballer Yudi Simelani from Kwatema, who was gang raped and grossly stabbed to death merely because she was lesbian. The brutal rape and killing of 17-year-old Anene Boysen from Bredasdorp. Now, I will give this document to the Honorable Court to read. Nowhere in this document is she referring to Section 6011 as a legal weapon to refuse bail to all people who have committed these gruesome murders. I wish to hand this document to the Honorable Court, and may it be mine.
Can you get a copy?
Oh, you can make copies? Yeah, sure. Now, what I'm simply trying to get at, these gruesome murders are not happening only to people in Sandton. They are also happening in Kwatema, Springs, Mamelodi, Mabupani, Durban, and so on. Now, are we to suggest that in all these crimes which are happening, all except for some which I've mentioned, including my client, must be kept in custody, whilst others are being released for committing the same gruesome murders? That would be unfair treatment, really. Then we would argue going forward and submit that there wouldn't be any fair treatment of accused persons. And that would be an unjustifiable and unreasonable limitation to Section 9, 10 and 12. Now, I then proceed to read. I say, see also, Tebeka Meda, accused Arnold Terblanche, has been granted bail of 1 million in the Makanda court. The High Court set aside a previous order in the local magistrates' court refusing him bail. Former ANC MP Sibusiso Kula was granted 50,000 bail after an appeal. He was previously denied bail by a lower court due to threats against his children. I refer this oral court to the recent case of Nandipa Magudumana versus S. For Magudumana, why bail was refused? It was refused because the court found, even on appeal, that she's a flight risk and no bail conditions will assist the circumstance to limit the risk. But we shouldn't forget that the other three, which I mentioned, Teboho, J.D. Polo, and 2 others, were granted bail. They were granted bail because they satisfy the requirements, and it means each case is to be treated on its own merits, facts, and circumstances. You don't just wake up very early in the morning and decide, Makanya, I'm going to put him in jail. Yeah. And second to that, the Constitution doesn't work that way. It says Bill of Rights, and it says rights contained in the Bill of Rights are not absolute. 36 says limitation. So limitation has to be reasonable and justifiable. We submit there's no justification in the circumstances for this accused to be refused bail. Unless if the extraneous reasons or factors which are beyond the factors governing the bail chapter, and we don't know about them. Paragraph 28. The evidence of both the investigating officer must be viewed with great circumspection. Yes. The evidence of both the investigating officer and the private investigator must be viewed with great circumspection, particularly regarding to the behavior of the investigating officer and the prosecutor, and including also the private, failing to act honestly and failing by concealing exonerating evidence. This has to be seriously condemned by the Honorable Court. It needs the deprecation and to be condemned to the core. Now, I come to deal with the issue about the Section 40C. The likelihood, the attempt to interfere with witnesses or evidence as read. And we submit. It will be respectfully submitted that there is no evidence before the court to suggest that if released on bail, there's a likelihood that the applicant will attempt to interfere with witnesses or conceal or destroy evidence. May I posit that? The question which was raised by my learned colleague in cross-examination says, if we release you because you concealed before, then you might conceal other evidence. Which other evidence, really? And I wish to also mention that there is no proper basis. It is just unsubstantiated, empty, and lacks weight. Because the standard of these provisions is likelihood. It is not just a mere possibility. You have to show that there is a likelihood, and this likelihood has to be supported by evidence. Not in the form of an affidavit. The best they could have done is to get in there, into the witness box, and behave like we did, to say, why are we saying this? But an affidavit is nothing else but an act of cowardice, for fearing that we might tear the case apart and make it even look worse than the worst state it is in at this present time. Now, We also wish, the witnesses also are unknown, and it would seem state will rely on forensic evidence in the form of DNA, his phone, our client's phone, which could have helped us to come with an exonerating version. They have it. It's captured. It's Mahungela capture, right? And he said it in his own words. Please don't ask me too many questions. I am going to estimate. Reliable information is in my phone. But they say, no, we have your phone. But commit to a version. It's unfair, really. Let me then touch base on the state doesn't tell us what happens with the keys and the phone. They don't tell this court. We took them also for forensic. It seems they left them because they concluded we've got the right person. And that ignorance on its own makes one to wonder. Now, the other issue which the oral court has to take into account is the issue about private investigators. Private investigators in our law are viewed as experts. Some, and not all, of the private investigators act unethical for them to get a check. They act like hired guns. They act in a biased manner to serve the employer. And in so doing, they'll do anything, anytime, anyhow to satisfy their client. And we submit that in this case, it's possible that that happened. Why do I say this? If the family had confidence in the SAPS, why did they leave this matter in the hands of the SAPS? Because the SAPS are there to serve everyone. The SAPS are catching the Gau train running. And they want to say, we were in Joburg when they caught it in Sandton. I don't think there's a fair assessment. It's not their case. It's the case for the private investigators. And because they want to satisfy some people or their commanders, they catch the train. As to which destination does it reach, they don't care. Now, we submit that the phone, the watch, which my client never took, the keys could have said a different story to them. Because how do you have the keys and when you're not driving? And the only version we hear, she was walking. How do you walk with your keys under normal circumstances without having your vehicle? And we said, when we asked our client, there's parking there. Now, the other odd issue which cannot be left is that the photos shown stems from video footage. They did their own pick and choose. And it begs the question, why didn't they give us an opportunity to view it? I repeat, S versus Green, which was decided by the late Busielo J, says when the facts are centered around the video footage, it's a crucial evidence which might decide the case in favor of the state or the defense, and might constitute a prima facie case, at least for bail application. And really, if we saw the video footage, which says, boy, we see you dragging the body, boy, we see you having the rag. Boy, we see you having this instrument. Instead, what do we see? We hear, do you see this picture? How's the mouth? But the question which is crucial, which has to be asked, who caused it, is being omitted. There's deafening silence to that. We submit that if proper investigations were to be done, they will find the right criminal. With the deficient, poor quality of evidence, this case is just going nowhere. I can inform Honorable Court, at this stage, at this point in time in a bail application, nothing would have stopped me if we were in a trial to bring an application for Section 174 on all the charges, because there's no minimum of evidence as is contained in S versus Lubaka to link my client with the crimes which are preferred here. What we see is just second guessing, trying to throw the mud on the wall and hope that at some point it will catch. That's not how the law works. Now, about undermining the criminal justice system, Section 40D, as read with Section 68, it is respectfully submitted there is no evidence that there is in existence a likelihood that the applicant, if released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice, including the bail system. Cross-examination even didn't go to town with this issue. I don't intend to labor this point any further. I've dealt with exceptional circumstances, and I just need a 5-10 minutes break to deal with the affidavits. Worship will remember that we are given this 2 affidavits, and I didn't get time to get any proper analysis. Deal with them, show how shoddy, sloppy, and the case doesn't turn on them. They've got nothing to add, save for playing emotions, and that's it. So I humbly request, and I think after dealing with this affidavits, then I get to my conclusion, I wrap up.
The court will be adjourned at 1.
Thank you.
Complete. And then, but as it must first stay in the meantime, see.
Yeah, you'll make a copy of that.
Ah,